Hi, I'm Julie Labenz. Welcome to Win Without Law School. Today is another video in our trial series, and this is more information about objections at trial. So what I'd like to do first here is share my screen. And hold on, let me make sure I've got the right screen up. Yep, okay, good. All right, here we go. All right, that's loading. I'll come up in a minute. Here we go. So we're going to start here with Rule 2. All right, this is the applicability of the Arizona Rules of Evidence in family law cases. So you can see that this is the Rules of Family Law Procedure. And we're here in Rule 2. And so first we've got Part A, and this talks about what types of evidentiary rules are going to apply. So is it going to be the more limited rules of evidence, or will it be what we call the strict rules of evidence? The limited rules of evidence will apply unless one party, at least 45 days before trial, if a hearing or trial is set fewer than 60 days in advance, then a reasonable time after getting notified of the hearing, you'd have to file a notice of strict compliance with the Arizona Rules of Evidence. So generally, self-represented parties will not request imposition of the strict rules of evidence. That would generally be done by a lawyer. So if you get a notice, let's say the other side is represented by a lawyer, then you can know what this is about. And if the strict rules of evidence apply, then all of the rules of evidence are on the table. But if they don't apply, then we're in this subsection B. So if there is no timely notice to impose the strict rules of evidence, then these certain rules of evidence do not apply, and the other rules of evidence still apply except for provided in C and D. So let's take a look at C. A record of regularly conducted activity or reports may be admitted into evidence without testimony of the person who wrote the report. If the record is relevant, reliable, and was timely disclosed. So police reports come to mind on this one. You don't need to get the officer to testify to their report. Just showing the report is sufficient. That's going to be a record of regularly conducted activity because the policeman makes a report as a part of his job. That's part of his regularly conducted activity. Counseling records. Those are also records that you can just submit as evidence without needing the actual counselor who wrote the records to testify. So normally, if the strict rules of evidence are imposed, then yeah, you need to have the person who wrote the report there to testify to it. But if the strict rules of evidence are not imposed, then you can admit records of regularly conducted activity without having the person who wrote the report be there to testify. And then affidavits of financial information, any AFI required to be filed or served may be considered as evidence if offered as evidence by a party and admitted into evidence by the court. So AFIs, you can get admitted, and you don't necessarily have to have the party that wrote the AFI. You don't necessarily have to have them to testify it. You can just, or testify to it. You can offer it into evidence and have it admitted into the court. So let's take a look at some of these rules that are excluded: 602, 801 through 807, 901 to 903, and 1002 to 1005. So those do not apply. Looks like we got a question here. What is an AFI? That's the Affidavit of Financial Information. This is a required document that must be filled out if spousal maintenance is at issue, child support, legal fees, and it's a standard court document in family law cases. You can find the form in Win Without Law School or online, and it essentially summarizes each party's income and expenses. So you'd fill out your AFI, indicate what your monthly income is, what your expenses are, and there's also some information about your educational background, your work history, and stuff like that. So it is a standard form that's used in any case that involves financial matters. Okay. All right, I'm going to switch to this other page. Are you guys seeing here Rule 602? I don't know if I need to like stop the share and switch over or not.
Yes, I see Rule 602.
Okay, cool. All right, good. So I don't need to stop my share. So remember back here for Rule 2 of the Arizona Rules of Family Law Procedure, it's saying that this Rule of Evidence 602 does not apply. So let's look at Arizona Rules of Evidence for 602. This is the need for personal knowledge, and this does not apply. A witness may testify to a matter only if evidence is introduced sufficient to support a finding that the witness has personal knowledge of the matter. Evidence to prove personal knowledge may consist of the witness's own testimony. This rule does not apply to a witness's expert testimony under 703. So generally, a witness would not be able to testify about something unless they had personal knowledge of it. But that doesn't apply in family law if the strict rules of evidence are not imposed. So a witness could testify to a matter that they don't have personal knowledge of within the family law court. And then we've got this 801 to 807 that these also do not apply. And so these are the hearsay rules 1, 2, 3, 4, 5, 6, and 7. So hearsay is when somebody else says something. It's an out of court statement, and you're essentially repeating what they said. You know, it's kind of like that game of telephone and, oh, what was said? It doesn't apply. Hearsay is fair game if the strict rules of evidence are not imposed. Hearsay can get super complicated. So I don't want to go into it too in depth other than to say if the strict rules of evidence aren't imposed, then it doesn't apply in the family law context, as we saw here. 801 to 807 do not apply. And then we've got 901 to 903. Let's see if I can get to that. There we go. This is authentication and identification. So this has to do with, this would be like the policeman authenticating his police report and saying, yes, this is a fair and accurate copy of the police report that I wrote in this particular case. But as we know from Rule 2C, you don't need the person there to testify about it. You can just have the report admitted. And so that's why 901 to 903 don't apply, because records of regularly conducted activity can come in when the strict rules of evidence don't apply. All right, and then we've got, okay, we did that. So we've got this final one, which is 1001 to 1008. And this is contents of writings, recordings, and photographs. So requiring an original, admissibility of duplicates. This is all about how a document needs to be presented to get admitted into evidence, but that doesn't apply in family law if the strict rules of evidence are not invoked. So really a lot more comes in because you can have hearsay, you don't have to have personal knowledge, you can have a record where you don't have the person that wrote the record actually there. Now that's different from, let's say you want to have a neighbor write a letter talking about how they see you playing with your kid and they think you're a great parent. That is not a record of regularly conducted activity. That is the neighbor writing a one-off letter, and that will likely be objected to and most likely won't come in as evidence at a trial because you can't cross-examine a neighbor's written statement. You can't cross-examine the neighbor about the details in their statement. And yes, it's true. If you don't have the policeman there, you can't cross-examine him on what's in his report. However, because he's making a record of regularly conducted activity, he's a policeman, he makes these police reports every day, it can come in. So be sure to be clear that you're working with a record of regularly conducted activity. Okay, so then other rules of evidence, including 403, still apply, except as in C and D. So let's just look at 403 real quick. Relevancy and its limits is what we're looking at. Here is 403. This applies. The court may exclude relevant evidence if its probative value is substantially outweighed by the danger of one or more of the following. Unfair prejudice. Okay, so these are really important. Unfair prejudice, confusing the issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. So these are some really good objections to make if, of course, it applies in your case. But if the other side is seeking to testify about or present evidence about something that would unfairly prejudice you, you can object, saying unfair prejudice. If they're starting to confuse the issues, you can object to that. Of course, we don't have a jury, so there is no misleading the jury in the family law context. Undue delay, wasting time, or needlessly presenting cumulative evidence. So let's say there's an allegation of domestic violence and the other side keeps going over it again and again and again. They're not presenting any new evidence. They just keep, and then domestic, objection, needlessly presenting cumulative evidence. We've already heard about this domestic violence incident. Let's move on. So these are some objections that can be made. And then let's look at 402. This will apply as well. Actually, this doesn't give us any really good definition of relevance. But the most important part would be 403 because there's a lot of objections to be made there. All right, let me, that's pretty much what I wanted to show you today is just looking at Rule 2 and some of the ins and outs of it. Objections are definitely very complicated. And so you want to simplify things. And one thing that can be helpful is when you go into your trial or hearing is to have a list. For example, like what's in 403, have one sheet of paper listed out, saying potential objections, and then list these: unfair prejudice, confusing the issues, undue delay, wasting time, needlessly presenting cumulative evidence, relevance. So you can have those in front of you and then have them top of mind if you need to use them during the course of your hearing.